we will take a look at the Chinese court through different lenses: the good, the bad, and the invisible. A business executive may ask, I have to file the suit right now, but a Chinese lawyer would have to think, which one is the right defendant? Who took the money? And who has the money to pay for our debts? When a foreign company has a commercial dispute in China court, one question usually comes first. Can I get a fair result in Chinese court? That is a fair question, but it is not where I would start. I would start with 3 more practical questions. What can the court see? What will the court believe? And if you win, is there anything you can actually recover? Because having a good legal argument is only part of the dispute in China. You also need the right defendant, the right evidence, the right timing, and the right plan for the whole asset recovery. So this series will not take you every chapter of the Chinese civil law procedure. Instead, we will take a look at the Chinese court through different lenses: the good, the bad, and the invisible. Let us begin with the good. Chinese court may have more practical power than many foreign businesses expect. Let's take asset preservation, for example. So in the right case, a party could ask the court to freeze the assets of the opponent party during or before the legal proceedings. That may include freezing the bank account or imposing restrictions on other property. Of course, it is not automatic. You need a proper legal basis. You may need to provide security, and also you need more useful information on the assets. And if you get it wrong, there also may be consequences. When the preservation works, it may change the situation very quickly. So imagine this: the other party is trying to fight for the case for years and manage the payment later. But at that point, the litigation itself is no longer to fight who is right. It has changed the commercial positions of both parties. That is something many foreign companies may not expect from the Chinese court. Now the bad. Many foreign companies may approach the case in Chinese court using their own habits from their own legal system. They would expect the discovery, which is wide. They may think a strong witness testimony will tell the whole story. And also they assume that a document which makes sense to their management team would also tell the same story before Chinese court. But it is not the case in China. China does not have a broad common law-like discovery, and written evidence is often more powerful than a witness's testimony. And before a foreign company even get to the substance of the case, it may take quite a long time for them to deal with the document, the power of attorney, the translation, the service, and other formalities. Cross-border cases can also take long. The service may take time. The fight over jurisdiction may also take time. An appraisal may also take time. The real problem is not how long the case will take. The real problem is that the company may have to continue making business decisions based on the wrong timetable. But the most important thing is not the good or the bad. It is invisible. By invisible, I mean something that cannot be read obviously from the law, but also could shape the results. The first invisible is, what does the court have in front of it? Your management team may have known what was happening. They remember the calls, the promises, and the meetings. But the court cannot make decisions based on the company's memories. The story has to be told through evidence, including contracts, emails, memos, invoices, payment records, and other evidence. Commercial story is not yet a court story. Someone has to turn the commercial story into court evidence. The second invisible is timing. Many companies started asking about enforcement after they have won the case. Actually, it is too late. You may have to ask, even before filing for the case, who is the right defendant? Does the defendant have any assets for us to recover? Where are those assets? Can they be identified? The third invisible is translation. I don't mean simply translating from another language into Chinese. What I do mean is the translation of two ways thinking about a case. So a foreign lawyer may think about convincing witness, but a Chinese litigator would think that what documents was formed at that time. A business executive may ask, I have to file the suit right now, but a Chinese lawyer would have to think, which one is the right defendant? Who took the money? And who has the money to pay for our debts? A claimant may focus on proving that the other party was performing badly. What the court needs is a clear claim, the evidence it could rely on, and the legal route it could follow. This gap between what happened in the business and what the court could act on is where many cases are shaped. That is the invisible part. This is what the series will focus on. Not a long and tedious lesson on Chinese court proceedings, not a list of legal terms. We will look at the decisions that could shape the case. Should you send the demand letter? Or could that warn the other party that you are ready? What evidence should you start to save and collect when you notice that this relationship is breaking down? What if the contract names one party, but the other party collects the money? When should you consider asset preservation and how to proceed with it? So what should a foreign company prepare before it speaks to a Chinese counsel? And when is litigation a bad idea, even if the law is on your side? For each question, we would explore the good, the bad, and the invisible. This purpose is not to make the Chinese court sound easy. They are not. The purpose is to make the foreign companies and their counsels to see important choices as early as possible. Because in the Chinese commercial dispute, the things that you do not see may be the things that determines what happens next. If your company is doing business in China or with Chinese, do follow this. In the next episode, we will start with a decision that often comes up even before the lawsuit itself. Should we contact the other side first, or without letting them know, prepare to free their assets?